Hello, my name is Ann Cleveland and I'm a paralegal at Liles Parker. Welcome to today's webinar hosted by the Texas Association for Home Care and Hospice. Today's webinar is entitled Avoiding Criminal Liability, Views from a Former Federal Prosecutor. Today's presenters are both partners at Liles and Parker, Robert Liles and John Pierce. Robert Liles is one of the managing partners at Liles Parker. In addition to a law degree, Mr. Liles holds both an MBA and an MS in healthcare administration. Robert has worked on the provider side as a federal prosecutor and now represents home health, hospice, and other healthcare providers around the country in connection with Medicare, Medicaid, private payer audits, and False Claims Act cases. John Pierce, a partner at Liles Parker and a graduate of UT Law School, is an experienced former federal prosecutor and trial attorney whose practice focuses on sophisticated criminal defense and civil litigation. Prior to entering private practice, Mr. Pierce served as an assistant U.S. attorney in the Southern District of California, the District of Columbia, and in the Eastern District of Virginia. While working as a federal prosecutor in the Eastern District of Virginia, he represented the office on the Attorney General's Advisory Committee for healthcare fraud. Since leaving the government, Mr. Pierce has successfully represented both foreign and domestic individuals and corporations in healthcare, commercial securities, corruption, export control, and tax disputes. He has also handled a number of whistleblower cases. He prosecuted antitrust claims worth $1 billion, defended corporate clients in commercial litigation, and conducted internal investigations. And now, without further ado, I present your speakers, Robert and John.
Thank you very much, Ann. I appreciate it. It's my pleasure to be here today with my good friend, John Pierce. Now, I've known John for many, many years. I was very fortunate and had the opportunity to work with John when we were both still with the Department of Justice.
That was a long time ago, Robert.
It was a long time ago, John. It seems like yesterday, but it wasn't yesterday, that's for sure. But John is, he, like me, went into private practice, and he is a partner here at Liles Parker and does really excellent work for our clients. So I'm thrilled to have him here today to kind of talk about what it's like to handle these cases from the perspective of a former criminal federal prosecutor.
Well, it's always nice to hear those kind remarks, Robert. You flatter me. I think what is important for our audience to keep in mind is, now that I've been out of the government for a long time, having done exclusively criminal prosecution for the government and now doing criminal defense and civil work, I think it's important for the audience to remember that allegations can surface in many different forms, allegations of wrongdoing. And it may seem something benign like an administrative matter, or maybe a little less benign as a civil matter, but it doesn't smell at all of a criminal matter to the providers. And one can lead to another and spin out of control. So one moral of today's story that I want everyone to take home is, please contact counsel when you get the first impression of the government thinking, or a government contractor thinking, that there may be something wrong with claims that have been submitted for payment. Because you really want protection from the outset. And what you want is healthcare counsel who understand how everything weaves together and how important it is to get out in front of any potential exposure. And certainly, if there's any resolution that is forged, you want experienced counsel to do what we call a global agreement that takes care of everything. Because, Robert, as you have seen so many times, there might be an administrative matter and it seems like it's taken care of quickly and easily, and then all of a sudden here comes the government seeking compensation for civil wrongs from the same conduct, or even custodial time for criminal wrongs from the same conduct.
It's interesting you say that, John. You're exactly on target. I agree completely. there is a case that was announced, gosh, it can't be more than a month ago, probably, out of North Carolina, where the U.S. Attorney's Office is prosecuting a physician, and in the press release, they note that the case originally arose as a UPIC audit. And I believe that there were allegations, it's been a while since I looked at it, but I believe there are allegations that she doctored the paperwork or did something improper in connection with the UPIC audit, and that UPIC audit had been referred to the U.S. Attorney's Office, and now she is being prosecuted criminally for a lot of things, not just what the UPIC auditors alleged. So, you know, it really is, I mean, we're at a point where these CMS contractors, they have a lot of power. If they identify conduct that they think is wrong, it can result in a criminal or a civil referral.
Well, I hate to divert into some legalese, but let me just tell the audience some of the dangers with that. We all know the Fifth Amendment is something that allows Americans to protect themselves from incriminating themselves, but that only kicks in what we call a custodial environment. If somebody is either under arrest or to be arrested in the minds of the police, then they have to give the warning that, hey, you don't have to talk to me, because if you do, what you say can be evidence to be used against you. Well, the UPIC folks don't have to give any warnings because there's nothing custodial about their discussions. But everything that is said to a UPIC person is a statement that can be admissible in a court proceeding. And it doesn't matter if it's a civil or a criminal court proceeding. So it may be that your office manager or you or somebody handling the phones at the front desk thinks that they can get rid of a UPIC person who's on the phone or divert them from the trail or whatever, just, you know, may shrug it off as something unimportant. But the problem is that whatever is said, now the government can consider that evidence, and if it's something that's false and they can prove it easily, well, then that's evidence of guilt of saying something false. And if it's true and it's bad, well, that has the same problem. So it's very important, again, to stress again, at the first instance that you have any impression that the government, whether it's a UPIC auditor or someone else operating on behalf of the government, wants to speak with you, particularly in person, it's time to call your lawyer and get some help. And it should be a healthcare lawyer, because this is a nuanced area. And if any of you are old enough to remember the old Fram oil filter commercials with the serviceman saying, you can pay me now or you can pay me later, but one way or another, you're going to be engaging counsel if things spin out of control. So get them early.
You know, John, it reminds me, my grandfather, of course, was a Texas judge, and when he wasn't a judge, which of course in a state judge you're elected, when he wasn't acting as a judge, he was in private practice. And I asked him one time, I said, Grandpa, what's your area of focus? And he looked at me, he said, whatever your problem is, that's my specialty. And you got to watch it. You got to watch it. You know, you don't want to use the lawyer that handled your cousin's second divorce. You want to get somebody that does this kind of work. But you brought up an interesting point, John, and it really kind of segues well with our first slide. And you're talking about the fact of individuals talking to investigators, individuals who end up under the microscope. And the fact is that DOJ, I mean, this has been around for a while. We're going to talk about it in the second slide as well. But individuals are really the focus these days, aren't they?
Well, Robert, early in our careers with the government, and I don't even want to admit to these folks how many decades ago that was. But back in those days, it used to be that when it came to white collar crime, with enough negotiations, the defense lawyer could convince the government to just take a plea by the corporate entity, resolve the matter with some fines, And the executives would, whether it was a hospital, whether it was an auto company, whatever the entity was, the individuals would have, no skin off their noses for the conduct. And there was a turn with the government while we were still with the government, but certainly since we've been in private practice, that it doesn't make any sense not to hold people individually responsible for white-collar crime when we hold people individually responsible for violent crime or drug crimes or any other kind of crime. So there has been a transformation with the government that if there is a white-collar criminal offense, there will be people held accountable, not just the corporate entity. So you can expect that whatever the healthcare offense, that the government is going to insist on resolution, including criminal resolution against individuals. So somebody is going to have to take the hit, and the government is going to do their best to work up to the top of the organizational chart to where the decision makers are and hold those people criminally accountable. And the way they do that is typically to start at the bottom of the organizational chart and threaten prosecution or actually prosecute until they get cooperation from the people up the chain of command to ultimately hold the decision maker, the ultimate decision maker, responsible.
Now, this slide really kind of reflects the fact that the current administration is in fact holding the line and going after individuals. But if we go to the next slide, you can see, I mean, going back this isn't that far back, but back to 2015, the Yates memo, I mean, that was really, I'm not saying that it wasn't occurring before the Yates memo, but this was really kind of an internal codification, if you will, of the practice. And they were coming, and DOJ essentially came out and said, we're not just going to go after the companies. I mean, because when you think about it, it makes sense. A corporation is a fictitious person. A corporation cannot violate the law. It's people in the organization. Next slide. And John, home health and hospice, they're no exception to this rule, are they? I mean, they're going after the owners. Who else are they going after? The marketing people?
Well, again, they'll go after everyone in the organizational chart. And let's face it, many of these home health agencies are smaller, certainly relative to a large corporation that might have an organizational chart that's pages long. But no matter the size, and no matter the type of company, home health, hospice, whatever it is, absolutely, the individuals are being held accountable. And if it's, let's say it's somebody who's responsible for the billing and they know that billings are going out improperly, that person's going to be held responsible. And they're going to want to know, the government's going to want to know, did it stop with you? Are you the one that was intentionally sending out wrongful bills? Well, usually the billers aren't in for any financial profit from sending out improper bills. It's usually somebody else who's gaining the advantage, usually the owner. And so the biller is going to explain, no, I did it at the direction of the owner. Once again, they're going to work up the organizational chart to hold whoever is responsible for the criminal conduct, but they're not going to let it just stop at the entity itself.
And it's important to remember also, isn't it, the fact that there are so many moving parts when it comes to providing home health and hospice services. You've got physicians, you have certifications that are required, you have referrals, the original referrals. Who is doing the face-to-face? Is the person properly homebound? You got nurse practitioners, physician assistants. You have PTSD and OT. You've got all these therapists that are coming into the homes. And every one of those has a relationship, a business relationship. And it's those business relationships that sometimes can run afoul of the anti-kickback statute. In the case of home health, Stark, for instance, there are all kinds of problems that really can arise. And that makes it kind of tough. Let's look at some of the recent cases. Now, these are not limited to just just Texas cases, because frankly, most of the home health and hospice reimbursements are based on Medicare, not based on state-based Medicaid. Although there's probably a fair number of folks on this call that do take Medicaid. But this first case I think is interesting because it involves a patient recruiter. What are your thoughts about marketing and those types of issues? I mean, the marketing representatives, every one of our home health and hospice participants probably has some marketer of some type.
Well, whether it's home health or hospice or some other type of business, in order to survive, a business has to have business. And a home health agency requires people that are homebound that need medical assistance. And it needs to be the type of assistance that is something that can be paid by typically insurance, whether government insurance or otherwise. So yeah, you've got to have a patient base. Well, how do you get your patient base? As you mentioned, a lot of times there are marketing folks, whether they're in-house or more often out-of-house. So what does a patient recruiter who can refer patients to the home health agency, what do they do to get their stable full of potential patients? Well, as so many cases have demonstrated around the country, sometimes they're paying people to get names. They might be paying a company that's got a boiler room full of people making phone calls to solicit potential patients.
So you've seen a lot of that with the telehealth and DME cases recently.
Absolutely. Well, there's telehealth. There are phone banks of people doing marketing for all sorts of things, whether it's telehealth, whether it's durable medical equipment, or whether it's potential patients for home health services. So there's an angle of people that are going to want to pay by the patient for the referral. And then that gets passed on to the marketing person, who then may have a consulting agreement with the home health agency. There should always be a contract behind any arrangement between a home health agency, a hospice agency, and a marketing firm.
But you have to be really careful, don't you? Because
that's my next point, is because so often your marketing company is going to come to the home health agency and say, well, I've got this standard agreement. My lawyer has already reviewed it and it's all in compliance. And so the provider signs up, and it turns out that there it is in writing that it's demonstrating a compensation on a per patient basis. It's just an admission of a kickback right there in the contract. And so many people in the agency, the home health agency, they have no idea that what they're signing is a contract that amounts to an admission of wrongdoing. That's another example of, don't trust that somebody else's lawyers looked at it. Make sure that you engage an attorney, a healthcare attorney, to take a look at these agreements. And I'm sorry to say that you and I have both seen some of these contracts approved by an attorney because they weren't a healthcare attorney. They didn't understand the exposure. But your question was, how can all of these different angles expose the home health provider? You've got the patient recruiters. You've got to get a certification from a doctor that the person has a legitimate home health bound need or hospice need for services. And sometimes those are sold, if you will. A referral from a doctor sometimes brings a kickback to the office manager of the doctor, to the doctor him or herself. I mean, there's a lot of hidden illegal financial arrangements that all need to be fleshed out. And if the government is going to be quite willing to assume that whoever is benefiting from that type of financial arrangement is knowingly involved in it, and they're going to come after you criminally, if not civilly, for under a whistleblower theory.
And on this patient recruiter case, in this particular case, it's a little unique because they were actually allegedly giving money to the Medicare beneficiaries. But as you pointed out, A lot of times it can be to a doctor, it can be to an office manager, even a nurse that somehow has the ability to steer patients to a agency. But folks, it's important to remember if you do have a marketing person, I don't care what you call them, whether it's a patient representative, a patient recruiter, a community ombudsman, whatever you call them, you have to really be careful. As John pointed out, the contracts, if they're not a bona fide employee, okay, if it's an outside individual, an independent contractor, the only way to properly compensate these people is some kind of scheme that does not vary by value or volume, okay, because otherwise it won't meet the requirements of the personal services safe harbor under the anti-kickback statute. Now, if it is an employee, a bona fide employee, you have more flexibility in how you compensate these people, but it's got to be a bona fide employee, and that means it's got to meet all these requirements that the Supreme Court has set out. It's not the same as the IRS factors. So the point is, these are very complicated business relationships, and everyone on this call has a marketing person, and you need to double check and make sure that your relationship with that person does not violate the anti-kickback statute. And it's especially tough because these are folks that are out in the community, and you don't really, despite the fact that you may want to keep a pretty close rein on them, it's tough. You don't really know what they're doing in the business relationships that they're engaging in and their conduct, and that conduct can blow back on you. So really be careful.
There was one other thing that you mentioned, Robert, that I wanted to highlight, and that is that I know this is a Texas audience, and for whatever reason, whether it's state or federal entities in Texas, they are very aggressive with healthcare enforcement.
Yes. And part of the reason is because the highest Medicare expenditures per beneficiary are in South Texas.
And a lot of that is because it attracts people for retirement, whatever the reasons. There is a lot of expenditure in Texas, so there's a lot of enforcement in Texas, and you get a lot more circumspection if you're operating a business, a healthcare business in Texas, than a lot of other places.
The second case, this Illinois case, just very quickly, the whole reason I put this case on there is because it just kind of really illustrates the fact that you got to watch who you hook your wagon to, folks. I mean, this guy was a consultant. He had a consulting company and was supposedly supposed to be helping home health agencies around the country. And in fact, somehow he talked 20 home health agencies in Illinois, Indiana, Nevada, and Texas into hiring him. Well, then what he did, as soon as he got a hold of the electronic medical records for these companies, he apparently engaged in just a freewheeling effort to bill for services not rendered, caused the system to pay out $48 million for services not rendered. It's just a mess. And the problem, of course, is when the government comes after this individual, by the way, he was doing this from afar. This is another illustration of, know who you're doing business with. This is a pretty basic thing. What's the first thing our mom has told us, okay? They said, you're judged by the company you keep, all right? Make sure you do due diligence before you hire anybody to do consulting work for you. Anyway, I can guarantee you every one of those home health agencies is probably being looked at to see what was their role in all of this. Did they exercise due diligence? Did they benefit from this fraud? Okay, so be careful. Next slide. Now this slide is a recent case that just came up. And it's a case that probably everybody on this call knows about. It was a very, very large home health and hospice prosecution that took place and in Texas, out of the Southern District of Texas. And they convicted the owner of the hospice chain and the administrator, and they got a long time, 20 years in prison. The administrator got 15 years in prison. But what happened after the conviction?
Well, I believe this is the matter that where after the criminal conviction, the government used the statutes to say that if you are guilty of a healthcare crime, you're stopped from defending a civil allegation based on the same conduct. So it didn't stop with custodial time. What resulted after the criminal conviction were civil false claim suits that then sought disgorgement of whatever was left after the whatever criminal penalties were imposed. So it goes on with the potential exposure for those left behind financially after a criminal conviction.
So this is tough. This is kind of reflective of what we're starting to see. And that is, if you have a kickback case, if there's a plea or a conviction, it's not over. Which kind of goes to the very point that you made in the very beginning, John, about the importance of doing some kind of global resolution. Because here it's a death of 1,000 cuts. If first they convict them and throw them in jail, and then to the extent these guys had any money left, now they're going to be getting that through the False Claims Act.
And I wanted to buttress something that you said earlier about in the context of marketing, and that is that let's say it's an outside firm, and you've used this marketing company, and you learn that the marketing company is in hot water with the government for other arrangements. Well, don't wait for the government to contact you. That's an example of where you need to reach out to your lawyer. All the communications with your counsel are privileged, so even if you're admitting something that you think may be wrongful to your lawyer, it doesn't matter. It's confidential. But you should reach out to your healthcare lawyer and tell them, hey, I had an agreement, I had a contract with these marketers, and they seem to be in trouble elsewhere. Can you look at my agreements? Can you talk to my people and see if I have any exposure, and so that you can get out in front of it?
Okay, so next slide. Let's talk about the primary, we're going to talk real quickly about a number of the criminal statutes that are likely to come up in a home health or hospice prosecution. I believe that the most common statute to pop up is the anti-kickback statute, because, as we discussed, there's so many different relationships, and that's where you have to really be careful, because it's one of those business relationships. If they go south, you've got a problem. The purpose of this slide, though, is to kind of show the participants today, the kickback statute's been around forever. But when it was first passed, it's really kind of interesting. First of all, it wasn't a felony, it was a misdemeanor. Second of all, at that time, they didn't really even have this whole concept of knowledge and willful or intent, willful conduct or intent as part of it. It was then amended in 1980, and that's when they first threw in the knowing and willful conduct provisions. And then, next slide, and then now, after the Affordable Care Act, they made more changes to it. And one of the things that they did was they took the fact that you had to have knowledge and you had to willfully violate the statute, and they amended it to say that you no longer are required to have actual knowledge or specific intent. Now, what does that mean for a lay person, John? What does that mean when you can violate this criminal statute, but you don't even have to have specific knowledge or willful intent to violate it?
Well, that's what you're pointing out, is that this is an example of a statute that's evolved to no longer require knowledge of the statute itself and the knowledge of the law in order to be guilty of violating it. Instead, you only need to be knowledgeable of the act and intending the act that is viewed by the government as criminal. So the knowing and willful is to the conduct that leads to enforcement. It's not the knowledge and intent to violate the statute itself. So that's called general intent instead of specific intent. With specific intent, you have to actually know of the law that you're violating and know that you're violating the law and intend to, not with a general intent crime. Most crimes are general intent. And They simply evolved the law into general intent for its application in the healthcare context. And think back, folks, to why do we have kickback? Why does the government prohibit kickbacks at all? The whole idea is that somebody who's applying their medical expertise in judgment on how a patient ought to be treated shouldn't be impacted or prejudiced in any way based on what they might be paid, depending on what their recommendation or course of treatment is. So that's the theory behind the anti-kickback statutes. And so it was only important as far as the government was concerned and how the legislature had the statute evolved. It was only important that the person intended the act of being involved in a kickback, not the fact that there was a statute that prohibited it. And as we go over the next several slides, the thing that I want the audience to bear in mind is that the government has an entire menu of statutes that it can enforce in the healthcare arena. And Robert's going to be going over these, and we'll comment on them as we go through. But it's not just kickbacks that can get people in trouble.
Next slide. Now, as the kickback statute, certainly has evolved, now it's no longer a misdemeanor like it started out, is it, John? Now it's a felony. You can be fined $100,000. You can be excluded. You can be assessed civil monetary penalties. And under the Affordable Care Act, of course, violations of the criminal anti-kickback statute, okay, can be pursued as violations of the False Claims Act. That's the next slide. Okay, so that's why it's so important that you really make sure you have a good handle on these business relationships. Let's go to the next slide, the healthcare fraud statute. Now, the healthcare fraud statute is interesting, John, isn't it? Because it doesn't just cover federal healthcare programs, right? It can also cover private pay.
Now, that's an expansion of the application of the code in more recent years.
Yes.
Again, we're going back to the time that Robert and I were with the government. There was no such thing as a separate healthcare fraud statute. The government always prosecuted fraud based on their theories under mail fraud and wire fraud. So any use of the mails in order to commit a fraud, whether healthcare or otherwise, or any use of the telephone or internet or what have you in furtherance of a fraud, that's all the government ever used. And then they created this separate healthcare fraud statute to protect federal money, like Medicare. But then that was expanded to include any kind of a fraud, whether the victim was a private health insurance company, whether it was some other source of payment, or whether it was some federal source of funding like Medicaid, like TRICARE, that sort of thing, Medicare.
Now, what about obstruction, John? I mean, that's something that we've kind of talked about a little bit. I thought it was interesting that, obstruction of a federal audit is a crime, of course. Whoever with intent to deceive or defraud endeavors to influence, obstruct, or impede a federal auditor. I thought it was interesting that the definition of federal auditor means any person employed on a full or part-time or contractual basis to perform an audit or inspection on behalf of the government. Now, couldn't that include a UPIC auditor?
Well, of course it would. That gets back to our earlier illustration of it seems like a completely benign call if the UPIC auditor contacts the office, hey, we have some questions about these claims. And you have to be accurate and truthful from the get-go. And if it's just like any other answer to a question from law enforcement, if you have any sense that you're not completely accurate or forthcoming, that's the time where you want to pause and say, I think I'd like counsel to assist with this. So I'll get back to you. We're going to contact my lawyer and then we'll respond. And so that's there's nothing wrong with a call from UPIC or a surprise visit, or certainly a planned visit from UPIC, that you take an opportunity to say, well, I have people that assist with this part of my business, and I want to make sure that they're involved, and so that you get accurate information. And that's when you take the time to contact your healthcare counsel and bring them up to speed.
Next slide. Okay, the next one, the reason I wanted to talk to you about this one, aggravated identity theft. I mean, I think this is a really interesting example of how statutes have kind of been repurposed, if you will, because now it's very common for us to see identity theft thrown into indictments for all kinds of healthcare fraud cases. Okay.
The aggravating, this was a statute that I never heard of when I was in the government. And that's because it was intended for people that stole a driver's license and then tried to use it, or stole somebody's identity and tried to victimize them financially one way or another. But now, anytime that there is a healthcare claim that's submitted, the government's been adding this theory that, well, they're submitting a claim based on private information about this person's healthcare. So we're going to say that they're also misusing the identity of that person. And the real aggravation of it is that it is a consecutive 2-year term of imprisonment to whatever the underlying offense is. So the government uses it as a hammer to say, well, if you plead early, we won't add the identity theft portion of the crime, which is going to carry an additional 2 years no matter what. We'll just prosecute for whatever the underlying healthcare fraud theory is. So it's, this has only been used in this context since I've been out of the government. So of course I see it as offensive conduct by the government.
Well, it is kind of a big, it really is kind of a big stick. And they're saying, they throw it in there. And like you said, either plea or we're going to add this on. And then whatever sentence you get, it's going to be 2 additional years.
And I just think it's a fabrication of, trying to twist the statute into an unintended use. I just don't like the theory behind the way the government uses it. And sometimes, depending on the prosecutor's office, they don't use it. But other times they wield it like a big old sledgehammer to try and coerce people into early decisions about a criminal guilty plea. Okay.
All right. So let's talk about some of the, here's some more statutes real quick. False claims on the civil side. We've seen this a lot. That is not this false claim. This is the criminal version of false claims. There is, of course, the Civil False Claims Act that we talked about in connection with the anti-kickback statute. Here is the criminal false claims.
And I think the moral of the story is that the government can use many different statutes to pursue the same conduct. So being able to defeat an element of one statute for particular conduct doesn't necessarily save you from the same conduct being charged some other way. So lots of different ways the government can use the U.S. code to its benefit.
Yep, like false statements involving healthcare, just general false statements under 1001.
Well, we use the same illustration all the time that people can relate to, but most everybody's familiar with Martha Stewart being prosecuted. The underlying matter was that she got inside information to trade on securities, which is criminal conduct. But she would never have been prosecuted for that, except when the FBI went out to talk to her, thinking she was a mere witness, and they just wanted to find out who passed on the confidential inside information to you that you made that money on, and she lied to them. So they ended up prosecuting her for making false statement to a government agent. just the FBI agents that showed up at her door one day. So that's another example where if you're talking to the government, really good to have a lawyer next to you who can help guide you, because just talking to the government, if it's not truthful, that's a separate crime, and it's charged frequently in the healthcare context, particularly when it might be difficult for the government to prove its underlying case, but they have what they can prove are lies made to their investigative agents.
Okay. All right, next slide. Some of the problems, these are kind of common problems that we've seen. You guys, you have to make sure that your folks, your nurses that are working for you, the PT, ST, OT, therapists that are coming in there, make sure everybody is properly licensed. Not typically a criminal problem, but as John has indicated, it's not that hard to turn an administrative or civil issue into a criminal problem if you're not careful. Okay, let's go to the next slide. Failure to document medical necessity. This comes up on the home health side and the hospice side all the time. And you really have to be careful. And especially like hospice, for instance, you may have multiple LCDs that you have to refer to depending on what is the diagnosis of the patient. It's really important that you look at the LCDs, you understand what the requirements are to qualify for coverage and payment, and you properly document it in the client's medical records.
Yeah, I'll give you an illustration that's outside the criminal arena on this. I have a whistleblower case right now where the LCD and the NCD are clear about what's required to establish medical necessity. And we've been reviewing doctor's records, and we haven't found one yet that complies with the LCD and the NCD in terms of what's supposed to be documented for medical necessity. So, folks, it's right there in the LCDs and the NCDs that tell you how you got to establish medical necessity. Make sure it's reflected in your files.
Yeah. Now, I've got my own concerns about LCDs and whether or not they really are applicable, but that's a whole different presentation.
And it's also on a case-by-case basis.
That's
so
right.
I'm being a generalist here by saying if there are written rules that tell you what you're supposed to do, get it documented. And then if they're not documented, then you worry about whether your lawyer can demonstrate that the LCD or NCD shouldn't be enforced as written. But you don't want to have to get there. Just try and keep records that reflect what the written obligations are purporting to be.
Failure to sign the treatment notes, that's another problem that we've seen. We normally see that as a problem on the administrative side, like a UPIC audit. The UPICs have been using that. If your folks didn't go through and affix that electronic signature to close out the record, they have been using that as the basis for denying claims. So you got to be careful. Consent forms, really important, of course, on the hospice side. We'll be talking about that in just a minute. Next slide. Billing for services not rendered. I mean, that's not something you normally see in home health and hospice, with the exception of that consulting case that I talked about just a few minutes ago. Misrepresentation of the provider of the medical service. We've seen that a number of times, not a whole lot in home health and hospice though. Next slide. All right, so John, these are some of the things that, and not all of these are criminal, but these are the things that pop up a lot of time in the criminal cases. Failure to qualify as homebound, failure to have a plan of care in place, and that kind of thing. What's your advice when it comes to compliance and making sure that you are meeting all these requirements?
Well, let's call the compliance plan the anti-prosecution plan. I mean, how to ensure that you keep yourself out of hot water with criminal authorities or criminal enforcement authorities. When it comes to these various types of indiscretions or wrongs, or however you want to describe them, Understand that there's a continuum in the minds of a prosecutor and a criminal investigative agent of what conduct is least egregious and most egregious. The lack of medical necessity, which requires a determination of medical judgment, that may be in the mid-range of what would be considered criminal conduct. Billing for services not rendered is probably at the top of the range in terms of what would be considered criminal or not. Well, that's just stealing in the eyes of the government. If you never did what you're billing for, that's just theft. So in that respect, it's good that that's not a common problem in home health related services. But in terms of what types of things and how to avoid any of these allegations with a compliance plan, there again, it's you want to consult with an expert in medical care or in healthcare, and particularly one that's an expert in providing home health services to help create the forms that will allow you, the provider, to just go through a checklist of things to know that in each case you're covered from the various indiscretions that the government might try and come after later. And the compliance plan itself, which again, you want that prepared by somebody who's qualified to prepare it, somebody with a healthcare law firm or otherwise, that is can operate as a sword, not just a shield when it comes to the government, because if you have a compliance plan in place and you're following it, then that gives your lawyer a huge defense mechanism to say there's no intent here. They hired counsel. They relied on counsel. Counsel set up a good, strong compliance plan, and they followed it. So there's certainly no intent to violate the law. To the contrary, there is an intent to comply with the strictest sense of the law. So, that's how a compliance plan can be used to help offset any of these various types of allegations of wrongdoing.
Okay. All right. And now, just to be clear, when you're talking about this checklist, you're talking about on the compliance side doing the periodic internal reviews, the internal auditing and monitoring. You're not talking about the medical records themselves. I mean, you got to be very careful because the government doesn't like checklists when it comes to medical records.
Right.
But that very well could be a good way for you to document that you are doing internal auditing on a regular basis.
Yeah, I meant it more in the metaphorical sense of having a checklist of how you approach treatment with any particular patient, not within the chart,
right?
But how you approach the providing the services.
Yeah. Next case or next slide, we'll see the hospice list. Consent is something that is so important these days because the government is very concerned about these patients being fully informed that, if you sign up for palliative care, you're no longer going to be getting the Medicare standard benefits anymore. I mean, you're going to be waiving that essentially, except of course in other things unrelated to the diagnosis for hospice. Underutilization, that's been a big issue. The government's very concerned about that. And then of course we have improper inducements again. We've seen a number of kickback cases on the hospice side, a number of kickback cases on the home health side. And we're getting pretty close. Next slide is reducing your level of risk. John, you talked about a compliance plan, but what do you do if you're working for a home health agency and you identify problems and you go to management and management just ignores you? What do you do?
Well, that's where the whistleblower laws come in to protect somebody who, if they're going up their own chain of command to try and raise a flag that, look, we're doing things wrong that we need to correct, and you get rebuffed by the decision makers, and you have to go outside the organization to try and get compliance with the law, well, every employee is entitled to talk to law enforcement if that's what they feel like they need to do, if they can't get the attention of the decision makers and they're confident that what's being done is wrong. So,
but you may have cases where someone says, I don't really, I'm not interested in being a whistleblower. My question, John, for you is, do I, as an employee, have an affirmative obligation? Am I required by law to report my employer? And, I think the answer really is, if you're not personally involved in it and you're not doing anything to help hide the fraud, I don't think you do under the law. There is misprision of a felony, but we don't really have this isn't a squealer state. It's not Russia where if you don't turn in your neighbors, you're going to be in trouble.
Well, but it does raise the issue of the fact that it's also a crime to conceal a crime. So yes, knowingly concealing
that's the issue. If you're involved in the concealment, then you got a real problem. Now, that is not the case, though, I will tell you, if you're a licensee. Okay, because in Texas, most licensees, like doctors, if you know a doctor is doing something that violates the Medical Practice Act, there is an affirmative obligation to make a report to the board. And if the board finds out you didn't turn them in, then you've got your own problem.
And let me just go back to make one final point. When you talk about if somebody is raising a concern up the chain of command and they can't get movement, again, if you consult your attorney, consult an attorney who's an expert in false claims, that person, if you end up ultimately being a whistleblower, can protect your interests because there are recoveries to be made within reporting healthcare violations if the government's money has been wasted on it.
Yeah. But I will tell you, my experience working with home health and hospice agencies around the country has been that if an employee brings a problem to management, it usually isn't a situation where management ignores them. A lot of times they just don't take the action that the employee thinks is necessary. And see, this is management's fault, and this is where management's dropping the ball. You can't leave the employee thinking that you're ignoring them. If they're wrong, and many times they are, you have to show them why they're wrong. You have to say, thank you for bringing this to our attention. We appreciate it. Now, if they're right, you take corrective action, whatever that entails. If they're wrong, though, don't just ignore it. You go back and show them, here's what's required for coverage and payment. Here's what we're doing. We believe that we're meeting the requirements. Okay, so that's the best way, because people ask me all the time, what do we do to reduce the likelihood of a whistleblower? And my response is, well, you got to be responsive, and you need to, when people bring problems to your attention, you need to make sure that that you've addressed those problems, and you go back and you explain to them the actions that you've taken. They may not agree with you, but you've looked into it. Sometimes they are going to bring things to you that in fact are mistakes, and you need to correct those mistakes. And to the extent you owe any money, you got to pay it back to the government.
And with my criminal defense hat on, I just want to emphasize that if somebody wants to be a whistleblower in an organization, if they make a complaint, nothing wrong with contacting your healthcare counsel to make sure. We don't think that there's anything wrong here. Are we correct? So limit your exposure to criminal liability by making sure that if somebody complains about something, instead of just shrugging it off, run it up your own flagpole, and that may be with outside consulting of an attorney.
That's right. And that way, and frankly, that gives you a little bit of immunization, if you will.
Correct.
that you conducted due diligence, and you check with counsel to make sure that in fact, if you were wrong, that you did take corrective action.
Absolutely, because if your lawyer comes back and says no, that conduct is fine, then you've got that protection.
Absolutely. And I believe that that's it for today. Do we have any questions on there? No,
Look like it.
no questions on the board. So if you do have questions, and I know that today's presentation is one that you may not want to publicize your questions to everybody that's participating, but if you do have questions, always feel free to give me or John a call. John can be reached at 202-298-8750. We also have his email address here. And as always, we look forward to hearing from you if you have any questions.
And anytime you reach out for help from counsel, it's considered confidential and privileged.
Yes, sir. Very good. Thank you very much.
That concludes today's webinar. Thank you guys for joining, and thank you to our presenters, both John and Robert. Everyone from today's webinar will receive copies of the presentation slides via email. If you have any questions about today's discussions, as aforementioned, please feel free to reach out to either John or Robert. Thank you so much.